case briefs, and so much more. LSData's got what you're looking for.
In 1988, a case titled American National Self-Storage Inc. v. Lopez-Aguiar made its way to the Florida District Court of Appeal. The case centered around the idea that if a warranty or agreement is not usually contained in a deed and goes beyond conveying good title and possession of the property, it is not merged in and extinguished by the deed. American National Self-Storage sued Carlos Lopez-Aguiar for breach of contract, alleging that during the sale, Lopez-Aguiar had guaranteed that the property had access to water, sewer, and electric service capable of accommodating a 45,000 SQ FET building. However, when it turned out that water and sewer lines were not available at the property line, American was forced to pay $25,000 to access the distant lines. Lopez-Aguiar argued that the warranty had been included in the deed and was therefore merged into it. He also claimed that American had waived their right to enforce the warranty, as they had been aware of the line's inaccessibility before closing, but had chosen to proceed with the sale. The trial court initially ruled in favor of Lopez-Aguiar, but American appealed the decision. Ultimately, the court reversed the summary judgment, stating that the warranty must still be enforced. The court held that the warranty for water, sewer, and electrical service at the property line survived the delivery of the deed, as it was an independent covenant that extended beyond the clear title conveyance and possession of the property. The summary judgment for the seller was deemed improper, and the case was reversed and remanded for further proceedings to determine whether the warranty had been fulfilled.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.